Maintaining Ethics in a Time of Crisis. Today we have Rachel Cipoletti. She is the Chief Lawyer Disciplinary Counsel for the West Virginia Office of Lawyer Disciplinary Counsel. She has been with ODC since 2002 and became its Chief Disciplinary Counsel in 2008. Rachel also serves as Special Judicial Disciplinary Counsel for the West Virginia Judicial Investigation Commission. She is a frequent lecturer on ethics and professionalism for the West Virginia University College of Law, the West Virginia State Bar, and the American Bar Association. Rachel was previously an attorney with Legal Aid of West Virginia, and she earned her undergraduate degree in psychology and her law degree from West Virginia University. So thank you, Rachel. I will turn things over to you.
All right, so Monica asked me to do a CLE for the bar for different ethics issues that come up with regards to a lot of people are working from home right now, including myself at times. So there are some ethics issues that come up specific to the situation we find ourselves in. But the most important thing that I would remind everyone, including our office, is that desperate times do not call for desperate measures. As lawyers, we do have an ethical obligation to abide by ethical rules, and we have an obligation to lead by example in times of chaos and crisis like this. With that being said, holy crap, right? I mean, nobody knows what's going on from day to day. Are you essential? Are you not essential? Are you working from home? Are you working from your conference room? It's a lot to digest on a daily basis, and there are a lot of issues at play, including something that's near and dear to my heart, which would be your wellness. So please make sure that I do understand that it is an everyday crisis just to get from one place to the other with kids in tow and seeing your spouses every day. So there are some key issues that arise with regards to the rules and the current situation that we're in. And of course, the first one coming right out of the gate is always going to be that of competence. Our competence rule is the very first rule, and it requires us to provide competent representation to a client with the requisite legal knowledge, skill, thoroughness, and preparation necessary to the representation. What I would remind you of are that the comments to the rules can be particularly helpful, particularly when you're looking for guidance with regards to any issues that may arise. The relevant comments for today would be in an emergency, which I think a pandemic would probably qualify as an emergency. You can give advice or assistance in a matter which the lawyer does not have the skill ordinarily required for you to do so. Our rule presumes that you are competent and/or that you can become competent by learning. So if you are in an emergency, your assistance that you give to people should be limited to what's reasonably necessary in circumstances. And you need to make sure that if you find out later and quickly later that you have given the wrong advice, that you follow up on that. This has become particularly important with regards to right now with dealing with clients in a business situation that need to apply for assistance or loans, following up on those dates, making sure that you've advised clients about how to apply for example, temporary benefits to the government. If you may or may not understand the rules and the laws that are there, we assume that you're going to become competent, so you can give advice in an emergency and you will become competent. The other issue that arises, of course, is that of technology. When the court adopted these rules in 2015, they did adopt the technology amendments, which would include our assumption that you would become competent with regards to technology. Obviously, if you were on today's call, you are involved with technology and you've assessed the benefits and the risk associated with relevant technology through study. This particular aspect of technology or of competence comes up and is in play quite a bit as it relates to the current situation that we're in. If you are appearing remotely, there are some tips that have been widely circulated. One, of course, which is to make eye contact through the camera lens, not via the screen. You should adjust the screen before you connect to ensure maximum visibility to your face. Always be aware of what others on the call are seeing. You should try to do calls standing up, particularly if you're appearing for a hearing. There are quite a few hearings that are taking place around the country via Zoom, via different platforms. And if you need to make a long argument, you may want to decide to, particularly if you're a pacer, make sure that you understand that you will have more depth and breadth to your voice if you are standing around and moving, and it may be more natural for you to make the arguments in that way. Try not to close your eyes while you're speaking, or God forbid, pick your nose. Bear in mind that when you are speaking and someone else is not, while you are not speaking and someone else is, they may still be able to see you. So keep in mind all the time of what is being seen. It won't take very much work for you to look on the internet and watch horrifying videos of people who have not figured out what can be seen. And please remember to get dressed because they can see you. If you're doing a regular phone call, that's a little bit different. You can appear from your bedroom if you'd like, if you're appearing by a phone. But if you are on a Zoom call, make sure that you understand that the webcam can be a pretty broad survey of the room that you're in, and you should understand where that's going to go. Of course, in Florida, we can always wait for Florida to have some good fun stuff. In Florida, the Broward County bench had to release a letter to its, they did so virtually, a letter from the Honorable Dennis Bailey. And one of the comments, he does start out the letter by complimenting how the bench and the bar have both evolved to appear via Zoom and doing these Zoom hearings for the safety of the litigants and the lawyers as well as the clients. But then he kind of gets into a part where he's admonishing the lawyers and indicates that one comment that needs sharing, and that is that the judges would appreciate if the lawyers and their clients keep in mind that these Zoom hearings are just that. They are in fact hearings. They're not casual phone conversations. It's remarkable how many attorneys appear inappropriately on camera. We've seen many lawyers in casual shirts and blouses with no concern for ill grooming. In bedrooms with the master bed in the background, one male lawyer appeared shirtless and one female attorney appeared still in bed, still under the covers. And putting on a beach cover-up won't cover up the fact that you're poolside in a bathing suit. So please, if you don't mind, let's treat court hearings as court hearings, whether Zooming or not. I did read the entire letter from the bench, and it is a rather humorous aspect as far as what lawyers are doing. So I would remind you that, again, however you are appearing for hearings or court proceedings or depositions, that they are in fact still court hearings, and you too don't want to end up on YouTube as a funny little result. More things on competence. I would be remiss if I did not compliment both the court as well as the state bar on its planning and development of resources, including these webinars for our bar. The court was aware that if you one of the bits on competence for you is that you do need to be aware of the status of orders impacting our judicial system. And the courts issued several documents to govern the operation of the courts throughout the state to protect the court or the health and the well-being of court employees. The website that is included on this, you can go right to it, and the court has all of its documents with regards to the pandemic. And again, the bar has done a remarkable job of putting together its response plan and resources. If you follow this link, the court or the bar has put together a wealth of resources that you can deal with. That anything from how to get onto a platform, as well as some of these tips. And there are a lot of wellness resources that the bar has cultivated and put together for you. So I compliment their response and their activity with regards to this particular pandemic that we find ourselves in. The ABA also has a resource page, which is included on here for your reference. They have a lot of good stuff with regards to dealing with the pandemic as well. Okay, so the next rule that comes up quite frequently in this is diligence. A lawyer should pursue a matter on behalf of a client despite opposition, obstruction, or personal inconvenience to the lawyer. And again, I think probably a pandemic could qualify as an opposition or obstruction, and it's certainly been quite the personal inconvenience to a lot of people. A lawyer's workload must be controlled so that you can handle each matter competently. Unfortunately, that rule of competence and the rule of diligence are rules of reasonableness, but you do need to make sure that you understand you are still under the same ethical obligations to do so. It is critical that you understand what the timelines are with regards to your cases. if you do or do not qualify in the court's orders that come down. If there are specific local rules, make sure that you have checked with the Supreme Court to see what in fact rules are governed under the tribunals that you're in. Back to competence for a moment. This is one of the tougher rules. This Rule 1.16A2, which is the withdrawal rule, requires us to withdraw as counsel when any physical or mental condition impairs our ability to represent our clients. While certainly there can be unfortunate issues related to physical illness associated with the COVID-19, or in fact exposure to COVID-19, maybe you are in fact in a position where you have to care for someone who's been exposed or has the virus, and or you've been exposed and you are into the 14-day quarantine, it's certainly a factor to consider during this pandemic of whether you actually can represent your clients ethically. If you are afflicted and unable to work for an extended period of time for reasons outlined in this rule, you would need to withdraw as counsel. If you are not able to represent a client consistent with your obligations of the rule, you need to decline any new engagements and terminate existing relationships. A lot of these issues come up when a lawyer is ill, of course, but sometimes the issues come up when the lawyer has begun to suffer from any kind of mental or physical impairments that would impede their ability to represent clients. We've done a lot of work. The court has had a lot of focus, and of course, the State Bar's Judicial Lawyer Assistance Program has done a lot of focus on lawyers' mental health issues. So in a way, I think our bar, as well as the ABA, has been preparing for a crisis of mental health coming, because we've been in the middle of dealing with the fact that lawyers have a high rate of mental health issues. There was an article issued most recently from Law 360 about this being a test to support supporting attorneys' mental health. Are we doing enough? Unfortunately, this will give us a pretty good outlook of, are we doing enough? And my answer is always no, we are not doing enough. Attorneys are grappling with anxiety of a public health crisis right now. They're juggling work and family obligations at home. They're adjusting to physical isolation due to the widespread effects, or due to the widespread of COVID-19. And our efforts to support attorneys' mental health and wellness are paramount. Lawyers struggle with higher rates of mental health issues, including depression and probably problem drinking, than the average public. And the current environment, of course, is ripe with stress and anxiety for lawyers as well as everyone else. But we are now physically isolated, working from home with new issues of competence and trying to remote in. And it stands to exacerbate the attorney mental health crisis if we're not taking preventative measures. There are a lot of resources available to you. If you check out the JLAP's website as well, which is included on this on the outline, you can get in contact with them. They have a lot of good resources for attorneys in this state. I've also included the CDC's anxiety, stress and anxiety page with tips about how to manage stress and anxiety. This is a good time to look into those mindfulness apps that we've talked about before. I know the Calm app is very good, as well as a lot of other things that you can find on the Lawyers Depression Project. And of course, I've included NAMI. The best call that you can make sometimes would be for yourself or for a partner or an associate or a colleague who's in need of help. And people who are physically isolated right now, we're not able to see that they need help. But I would remind you that these resources are available to you, and please, please, please use them whenever you need them. They're a good thing to spread around through your local bar and make sure that everyone's aware of their existence. It always astounds me when I'm in a teaching situation and I say to someone, make sure that you understand that you can contact JLAB if you have concerns. And the question still becomes, well, what's JLAB? This has been around for a while now, and it is a well-organized project through the State Bar, and the phone numbers for Robert and Amber and are on this page, and you can contact them. They are accessible via email or telephone. Okay, so on the note of diligence, it brings about a good time to point out to you, again, before, my favorite comment to Rule 1.3 has always been the one on succession planning, because they do indicate in the rules that we've adopted that to prevent client neglect of matters in the event of a sole practitioner's death or disability, the duty of diligence may require that each solo practitioner prepare a plan in conformity with the applicable rules that would designate another lawyer competent to review files, notify clients of their death, and determine whether there's a need for immediate action to protect your clients. I have always pointed out this particular comment because it is important and can be very expensive and devastating to local bars if we're not taking care of our succession plans, particularly for solo practitioners. I pointed out to the fact that the majority of the time that I find out that a lawyer does not have a succession plan is when they're dead. And it's unlikely that I've ever pursued a dead lawyer for a violation of 1.3, and I probably won't do that. But I would point out to you, it's no longer just a good practice tip. And before I go to the next slide, I do want to again point out the link on this website to go to the plans that we have in place for you. There are a lot of good, just step-by-step letters as far as how you can set up your succession plan, and they are online and available to you at all times. And since you probably have some time on your hand, now might be a good time to do it, because it's no longer going to be just a helpful tip to you. As of January 1st, 2020, the court adopted the revisions to the governance documents for the West Virginia State Bar, including relevant provisions under Rule 14. The State Bar's new Rule 14 is under succession planning, and they do indicate in Rule 14 the duty of diligence. Again, they cite to the fact that Rule 1.3 does indicate that it would be important for us to have a succession plan in place for certain lawyers. And as of July 1st, you will be designating, if you fall within a certain group of lawyers, such as the solo practitioners, you do need to designate who your succession plan or who your successor is. That disclosure has to be made on or before July 1st and submitted in the form required by the State Bar. I know there's been some changes to our CLE requirements dates. I'm not aware that this July 1st date has changed as of now, but I am quite confident that the State Bar or the court will advise us by order if they do change the date. However, right now they are requiring us to disclose by July 1st if you're a solo practitioner who, as they'll be maintaining a registry, as who your successor is.
Rachel, this is Anita, and I'm going to pretend like this is a regional meeting and interrupt you like I normally do at those meetings. And the COVID-19 issues have caused a slam on the brakes on a lot of the implementation of the new rules. We are not going to be able to get the database changed for July 1 for registering succession planning information. We have a succession planning committee. We have talked about what we need to do. We are in the phases of implementing what we can. We have met with the court. They are in total agreement with what we are planning. This year, we need you to, as Rachel suggested, we need you to get all of your information ready, because next year on the database, as you are required to pay your fees, do your FRD and your IOLTA reporting, you will be required. It will be a mandatory item on the database that you record the information that the Succession Planning Committee and the court agree needs to be prepared. So even though we cannot implement it for this July 1, it will definitely be there next July 1, and there will be some changes, we believe, and speaking with the court, that this will not apply only, as the rules say, to solo practitioners. We believe the court will agree to expand it to firms of 5 or fewer attorneys. So don't rest on your laurels. If you're in a firm of 3, 4, you may be required to do this next year. So everyone needs to do it, but especially the smaller firms. Rachel, thank you for letting me interrupt.
Of course. Well, you have plenty of time now to work on these succession plans. It sounds like we've got a little bit of time to make sure that we're all getting it done correctly. If you have questions about the succession plan, you can certainly contact our office. I think the State Bar through their committee will also have some materials that'll be going out. But it is of critical importance that we understand how significant the succession plans are. One, they can be financially devastating if we have to appoint a trustee to go in and close a practice. But inevitably, it does fall on someone in your community to help step forward and do it. And it can be very stressful for those left behind in your firm and in your family. So do consider it. It is an obligation, and it's going to be an enforced obligation relatively soon. So we might as well go ahead and confront the realities of the situation and take care of the succession plans going forward. Okay, so the next rule that comes up is communication. This can be a little tricky in a lot of regards, particularly where we are now, as you know, we're in an exigent situation where we can't always meet face to face with your clients, which maybe for some of your clients, that's the best thing that's happened to you, is that you no longer have to meet with them face to face, but you do need to communicate with them still. So you're going to have to take steps to communicate with your clients in a new brave world that we're sitting in. So of course, the thing that I would tell you up front is that you need to be proactive with your clients. Perhaps the easiest means of communicating with clients might be still via telephone. But I want to remind you that if you're not in your office anymore, you may not want to use your home telephone to communicate with your clients. You may want to have a different phone number to communicate with clients so they don't have your home phone number, so they can no longer call you at home, or perhaps you are fine with that, that's fine. But those are just issues that I want you to consider with regards to communicating with them. There are also quite a bit of resources if you have an incarcerated client. If you go to the DHHR's website, which is on here, it does indicate the correctional facilities rules with regards to communicating with clients. There are obviously exceptions with regards to dealing with clients who are incarcerated right now. And they're still trying to do quite a few things remotely for attorneys, I understand. From talking to a couple of prosecutors and criminal defense lawyers, I know that there are quite a bit of issues that are resulting from where we are with regards to the virus, as far as dealing with clients who are incarcerated, getting them back and forth, should they be going back and forth. And I know that just like everyone else, there are a lot of stressful issues that are coming up with those clients. So please bear in mind, in addition to the typical stress that clients are under who are incarcerated, there are quite a few issues that are being exacerbated by the situations that they find themselves in as well. Email, this is a good time to keep in mind that when you're doing your client intake, requesting email addresses is a good idea, because a lot of lawyers right now are finding out they don't have an email address for their clients. So keeping a good email address for your clients is a good decision. I think at this point, if you do not have an email address for your clients or a phone number that's active, you're going to have to go with US mail. If you are not in your law office every day, you do need to communicate with clients who have active matters of what's going on with regards to your practice. Video conferencing is obviously a way of how people are communicating with everyone. Everyone from your second grade math class to this particular CLE through the webinars. There are, of course, some issues that come up with video conferencing, which we're going to discuss in a moment. But video conferencing is an easy and sometimes cheap way of dealing with clients. Texting, obviously, is also another aspect. I know a lot of you do text your clients already. Again, I would be remiss if I didn't remind you that if you are texting your clients and there is attorney-client communication, one, you're under an obligation to keep that confidential and keep it secure. And two, if it is something that has to be reduced to writing and put into the file, you need to understand how to do that with regards to texting. So just keep in mind that regardless of the communication efforts that you're having, if it in fact is something that needs to be in the client file, you would be under an obligation to figure out how to reduce it. If you need an original signature, you can collect them through a variety of e-signature tools. If you feel more comfortable seeing a client or a party sign it, You can have the user sign a document with a stylus while using a mobile device like an iPad or a smartphone. But a lot of this /s/ will also be fine with regards to the virtual signature tools. There are some third-party apps like DocSign that you can use that are safe and secure, that I know a lot of attorneys are using with regards to getting signatures. I also want to point out to you that in response to the COVID-19 public health risk, the governor issued an executive order which suspends the personal appearance requirements for notarization. The emergency rules modeled after the national standards for remote notaries, and the purpose, of course, is to keep the notaries safe as well as individuals, but to make sure that the validity of notarized documents can still be executed. After the state of emergency is over, these particular requirements will be revoked, but currently they are set forth, and you can follow, well, the application you can follow through this website that I've included on here, but the procedures are included in the 15345. That's particularly important if you're going to have anything notarized during this. You do have to go through an application process to get the e-notarization. So if you have notaries in your office, it's a good idea to have at least one or two of them who have the ability to notarize documents during this emergency. Another thing that I think is important to point out is that you need to have a central location to communicate updates about your practice. It's good to have multiple platforms if you're on Facebook or if you're on LinkedIn or wherever your firm or your practice appears, that's fine, but you need to make sure that there is a central place that you are updating what you're doing. If you're not in your office, if you're communicating via cell phone, if your phone has changed, all of this, you need to have one particular place where you're communicating the updates to the public as well as to your clients about what you're doing. You can have multiple platforms, you can update it in a variety of places, but it is critical that you do have one central place where you're updating everything on a regular basis. I think, again, the bar does a good job of pointing out or of updating us with regards to their resources that they have available to us, and the fact that it's so central and so easy to find on their website should be a good way to look and just see how they have done it. Okay. Communication is the one that's probably waking me up in the middle of the night about concerns that I have with regards to where we are right now with lawyers. Communication in the time of crisis, an attorney working from home or another remote location is under the exact same obligations to maintain client confidentiality. You have to safeguard electronic communications such as email, and you may need to take additional measures to prevent information from being accessed. This duty may require you right now to encrypt your email or require the use of passwords to open attachments or other reasonable precautions to assure that the contents and attachments are protected. This is going to vary on your client. If you have clients that require additional security that you had already used additional security with, or have aspects that absolutely require you to ensure, for example, guardian ad litem proceedings, you need to make sure that these clients' information is protected going across the internet as well. You probably don't have the same safety and security with regards to high-tech firewalls at your house, but if you are working remotely, you still need to make sure that you are taking reasonable precautions to make sure that their information is protected. If you are working remotely, you're taking documents, files, and other confidential materials to your house or other remote locations. You need to make reasonable efforts to ensure that other people in your house, be it your spouse or your child, who are not working in your law practice, don't have access to confidential materials. This is your duty to maintain confidentiality applies to all forms of communications, including phone calls, emails, chats, online conferencing, and text messages. I put together a quick list of stuff with regards to confidentiality in the time of crisis. You should not be using, this goes without saying whether we're in the middle of a pandemic or not, You shouldn't be using the unsecured free internet and Wi-Fi hotspots when you're communicating confidential material. If you tune into the Today Show for 15 minutes, they'll show you one of those things where somebody's sitting in a hotel lobby and somebody hacks right into their system. So you would not want your system breached. So be very wary and/or avoid using these unsecured free internet and free Wi-Fi hotspots when you are communicating with client materials. Video conferences should be secure. On March 30th, 2020, the FBI issued a warning about teleconference hijacking, particularly Zoom. I realize that's the platform that we're currently on, and there have been a lot of hijacking issues that have happened with taking over your Zoom networks. So the FBI did issue some precautions with regards to using these. Don't make your meetings public. You should require a password and use other features that control the admittance so you can see who's on. You should not share the link to a teleconference on an unrestricted publicly available social media post. Provide the meeting link directly to specific people. Have the host of the meeting manage screen sharing options. I know that Mike is doing that for us today. And ensure that users are using updated versions of remote access meeting applications. They are trying to update things as we go along and using this. Obviously, a lot of people from, again, my daughter's second grade class to her ballet class are all using Zoom platforms. So as people are using it more and problems are being addressed, make sure that you have the most updated version of the remote access meeting so so any kind of issues that are being addressed by the platform are in your updated access. You should update and use strong passwords. Now that we are doing stuff with regards to Zoom and people have webinars where the web cameras are active on your computers. I was on a call with somebody a couple of weeks ago, and behind their head was written their password because they were sitting at their desk. So all of their passwords were for their bank accounts and for whatever else were all written behind them and posted on a nice little sheet behind their head. So when they were on their webinar call, I could figure out how to get into their bank account. So please make sure that you are updating and using strong passwords on your account, not posting them right behind your head on your Zoom calls. Right now might be a good time for you to Google what VPN means and figure out how to use VPNs to make your network more secure. We do have a legal ethics opinion from 2012 that deals with the use of electronic media for file storage. This was obviously issued in 2012 and dealt primarily with the cloud. But again, it goes through some relevant rules, which would be competence and diligence and communication and confidentiality. Probably the one that scared me the most when I read it was if you're going to communicate confidential information, you need to unplug Alexa and Google Assistant and other smart devices around your home. When I read that, I was a little bit unnerved as my home computer was set up right beside of our Alexa. So I have since unplugged her and she is not listening to, she can listen, I call her she. Alexa in our house is a DJ for the most part and plays music and tells us jokes. But if you are communicating via at home now, make sure that you understand that these smart devices can and are listening to your conversations with your clients. So please make sure you do unplug them when you're communicating. Okay, so the next aspect that comes up a lot particularly with working from home is that we do still have responsibilities to maintain our responsibilities as partners and managers and supervisory lawyers. This applies to any lawyers who have managerial authority. I don't care what you call yourself. If you have the managerial authority in your firm over professional work in the firm, this rule is going to apply to you. It does also apply to government agencies, and the duties imposed by this rule on managing and supervising lawyers do not alter the personal duty of every lawyer in the firm to abide by the rules, but they do give you additional requirements with regards to supervising attorneys. Now, the things that I can tell you is, again, that there are responsibilities of a subordinate lawyer You're not relieved of the responsibility for a violation by the fact that the lawyer acted in direction of a supervising. We still expect you to know the rules, but it may be relevant to determine whether the supervised lawyer had the knowledge required to render the conduct a violation of the rules. But keep in mind, you do still have the same rules or the same requirements under the rules. This also extends to your lawyer assistants who are at home. I would remind you that the important part of this is that if we are all working remotely, you do still have obligations to supervise, and you must be taking reasonable efforts to ensure that work product and client confidentiality are in fact confidential, regardless of how and where they are created. If your assistants are at home, for example, and the subordinate lawyers are at home, that extends to them as well. You should be establishing remote work expectations and procedures for staff and checking in with them. All staff working remotely should be educated about the aspects that you're learning today, for example, about client confidentiality concerns, and that we do have duties to communicate with one another, and have resources to make their work compliant with the rules. Now is a very good time to make sure that you have antivirus software and that you've kept it current. Now is an incredibly good time to find out if you have anti-malware software and keep it current. Remind all of your assistants working from home. This should be something that you do on a regular basis, whether you're at home or not. But because you can't supervise it, and because, again, the firewalls may not be as protected to keep these emails from coming into your system, remind them not to open suspicious attachments or click unusual links that are in messages or emails. There are a tremendous amount of phishing that goes through emails that are being sent to us, and your filter at work may cipher out a lot of them because of the stronger firewalls at your offices. But just because we're in the middle of a crisis doesn't mean that there aren't going to be a lot of smart criminals out here targeting people who they know are working from home. So be sure that you do not click on these unusual links. Again, I would be remiss if I didn't point out the fact that Mike Mellis has maintained a cyber threats page on the State Bar's website, which provides information reported by lawyers about fraudulent cyber activities potentially related to the practice of law in West Virginia. If you become the target of one of these emails that you get, it would be good to let Mike know that what you've received, and he can update that page and make sure that we're aware of the fact that this is out here targeting lawyers. For example, in my office, all of our assistants got an email that looks like it's exactly from me, and asked them to go to I'm out of the office and I need them to go to CVS and get 5 gift cards to send to so-and-so. And the email looks like it's exactly from me. And so at least one of my assistants messaged me and said, I'm at CVS, what do you need me to get? These kinds of things that are published, obviously, as soon as I saw it, I knew it was, I knew I hadn't sent it. But secondly, I knew it was a scam as I was sitting in a CLE 3 days prior and had heard this particular phishing email that had gone out, because as soon as she clicked on it, they were able to access through her website, and they had put in different bugs that go through there. So
Rachel,
Mike, go ahead.
Anita again. I was going to wait till the end, but with this discussion, I want to interrupt you again. I apologize, but I'm going to make a pitch, as Monica did at the beginning. On Wednesday of next week at 1 o'clock, we will have a webinar that addresses the exact issues that Rachel is speaking of. One of our attorneys, a West Virginia attorney who works for the FTC, will be talking about fraud issues. They're going to be related more to COVID-19, but they're all relevant. And I will reiterate what Rachel said. If you get one of these scams, please share that information with Mike Mellis or me. We keep track of them, and if we receive 2 or 3, Mike does an investigation and will post the information. So please go ahead and send it. Even if you don't think it's significant, send it anyway, because we may be getting 3 or 4 or 5 or 20 of them, and we will let people know if we start receiving multiple numbers. Thanks, Rachel.
Absolutely. So The other thing about not being in your office is that you need to make sure that you are looking to lock the doors, check the windows and lock the file cabinets. If you're out for an extended period of time, and you might want to check your water lines to make sure that you don't have some tremendous leak in your office. So just check in on it occasionally. I know that the state is under a stay-at-home order at this point, but make sure when you are leaving all of your physical office space is open, that you check the windows, lock the file cabinets, as if you would be on vacation for an extended period of time. Just keep that in mind and make sure that you understand that checking in on your practice may require you to check in on your physical space at times. Okay. So our court made clear from the beginning that COVID-19 policies, that any individuals who fraudulently use public health efforts to impact court proceedings for personal gain or to avoid legal obligations may be subject to civil or contempt proceedings and or sanctions. And they were quick to put in there that attorneys violating the rules may be subject to referral by the West Virginia Office of Disciplinary Counsel. You know, we're always, I'm hesitant to ever say that lawyers would lie to the court, of course, but now is not the time to claim that your dog ate your homework with regards to claiming to the court that you have COVID-19 or that you need a continuance because your mom is sick with COVID-19. This is not a means for us to get out of our obligations. And the court was clear in the beginning that if anybody who uses this particular health crisis to advance their personal gain and to avoid legal obligations is going to be subject to serious sanctions from the court. And of course, attorneys would be severely looked upon, or we would definitely have quite a few issues with any lawyers who would be using this crisis to their advantage. And with that being said, that doesn't just mean lying. I would point out now is a good time to remind us that the standards of professional conduct are critical during times like this. The Los Angeles County Bar Association issued a statement on the emphasis for lawyer civility, and I think that they have said it the best. But suffice it to say, I think we are all in this together. But the LA County Bar's statement was, in light of the unprecedented risk associated with novel coronavirus, we urge you to liberally exercise every professional courtesy and or discretional authority vested within you to avoid placing parties, counsels, witnesses, judges, or court personnel under undue stress or unavoidable stresses regarding this health risk. So given the circumstances, you should be prepared to agree to reasonable extensions and continuances as may be necessary to avoid in-person meetings, hearings, or deposition obligations. Maybe you don't like appearing via phone or otherwise, and that you don't want to make this continuance, and that you've been incredibly excited about going to trial in a particular case. But right now is the time that we're asking you as lawyers to remind yourself that we do have obligations to each other to be courteous. I think sometimes we forget that. And right now, while we're all under an additional amount of stress with regards to this pandemic that is affecting us all, that now is the best time to remember that while we are all in the same boat, we may not all be in the same river. So you may be enjoying your time at home, and it may be easy for you to make these transitions, and you may have the technological support that you need, but that might not be true for everyone else. So I would remind you to keep in mind that other people are struggling in different ways, and that we should be courteous to each other. I return to my go-to line of, we are our brother's keeper and we're in this together. And the last thing that I would remind you is, if you have questions about your conduct, you can always contact this office. We are here. There is somebody who is answering our phones and checking our phone or our messages. We can communicate with you obviously via email. That's far easier to get in touch with the lawyers. Our website address is wvodc.org, and all of the attorneys' email addresses are on there. They do have access to their emails from home, and they are in and out of the office. So if you have questions about your conduct as it relates to the rules of professional conduct, as always, you can, of course, contact our office and get an opinion about your conduct. And we're here to help you as much as we possibly can with any resource that we have available. Monica, do you have anything else that you want to discuss or add?
I don't know if they can hear me, but if everyone can hear me, thank you, Rachel. It was great. I don't have anything else. Anita was going to close. I don't know if Anita has anything else to add at this point.
Just a couple of things. Rachel, thank you as always. Rachel is a very impressive speaker, but especially what she said today is absolutely essential information. Her presentation today has been recorded. Within a few days, Mike Mellis will be posting it to the website. I would strongly, and I mean strongly, encourage all of you who are listening to tell your colleagues that this is a webinar they should view. It will be available in a few days on the website. There will be a link to it. But if you are not participating today, please tell everyone they need to listen to what Rachel said today. To